Thank you everyone for joining us for our fourth information session in respect of mediation. We all know that the proposed judicial implementation and mediation workshop previously held was very informative, and we hope to bring you more information that will be productive in your particular practices. It is a privilege to share the next 45 minutes to an hour with all our legal practitioners, candidate legal practitioners, and all attendees. I would like to remind everyone that this information session is once again being recorded, and in all probability it will be uploaded onto YouTube. Accordingly, I will request that all attendees be mindful with their questions, comments, and statements. However, please take the liberty of asking as many relevant questions when we reach the Q&A part. My name is Yusuf Wadi. I'm currently serving as the chairperson of the Gauteng Attorneys Association, a member of Nadal Johannesburg, Soweto Legal Fraternity, and an executive member of the Johannesburg Attorneys Association. The GAA committee involved in this area of law is Conrad van der Vyver. He's the head of the Road Accident Fund Committee and executive member of both the Gauteng Attorneys Association, Pretoria Attorneys Association, and a committee member of the LSSA. Marianne Pretorius, she's the vice chair of the GAA, also the secretariat of the EEC meetings, both Johannesburg and Pretoria, as well as the chairperson of the West Rand Legal Practitioners Association. And we have Nicolette de Wit, who is our secretary of the GAA and also a High Court committee member. The agenda, as you all know for today, is we're going to do a brief introduction. We're then going to move on to an information and mediation in general. That is the mediation services and trainings which are offered by Conflict Dynamics. We'll be welcoming Marian Shear as well as Tefo Raditapole. We'll then do Q&A and we'll then move for closure. We would like this to be more interactive, so if you do have a lot of questions, please take the liberty of asking them, as we are told that the mediation practice directive is going to be implemented shortly. Thank you. Introduction: the Gauteng Attorneys Association, we all know, which is our provincial umbrella body when local attorneys associations, being the Johannesburg Attorneys Association, Pretoria Attorneys Association, West Rand Legal Practitioners Association, the Soweto Legal Fraternity, all form the Gauteng Attorneys Association. These associations play a vital role in each region. By being a member in good standing in any of these associations, you are naturally a member of the umbrella body, the Gauteng Attorneys Association. We've hosted 3 previous information sessions, and we undertook to provide legal practitioners insight to any information that is provided from the courts. And today we have the privilege of welcoming Conflict Dynamics. In terms of Conflict Dynamics, as far as I understand, they've been in existence for over 30 years in the industry. Legal practitioners are also reminded that we are still waiting for the finalized new practice directive. And as soon as that is provided through to us, it will be circulated to the entire profession. This is going to be the new format in which all litigation is going to take place in Gauteng. This information session is to introduce the membership to Conflict Dynamics, which will provide legal practitioners insight to this organization, provide content to mediation, and most importantly, accessibility to Conflict Dynamics as well. Conflict Dynamics offers the following services: employment relation training, mediation administration services, and a panel of trained, accredited, and neutral mediators. Conflict Dynamics, out of interest, has the following guides: a guide to mediation, a guide to online mediation for parties and representatives, a guide to online mediators for mediators, and, for most of us, High Court Rule 41A processes, including specimen forms, joint minutes, and agreements. I think those are important to go and have a look at in advance. Thank you. I'll now turn over to Conflict Dynamics. We call upon, and I'll be introducing Ms. Marian Shear, as well as Mr. Tefo Raditapole, and I'll ask them to actually do a brief introduction to themselves, and thereafter we'll move to the presentation that Conflict Dynamics is going to provide for us. Thank you. Marian, would you like to go first? Just introduce yourself to everyone.
Thank you, Yusuf. Yes, I'm Marion Scher. I'm very happy to be with you for this short, brief lunchtime meeting. My background is really very much in dispute resolution. I graduated from university a very, very long time ago. And my first job was in in an organization called IDASA, which immediately ages me. IDASA was the Institute for a Democratic Alternative in South Africa, and our job was really to speak to people at different sides of the political divide and try and encourage a negotiated settlement. So what happened is when the political parties were unbanned, I suddenly thought, oops, I better find myself a real job. And I applied to do a master's in dispute resolution specifically. And I did that in the US and then came back to work for IMSA, the Independent Mediation Service of South Africa, with my new dispute resolution skills, I guess. I've been in this industry ever since. I've worked mostly a lot in training. Initially in IMSA, it was much more around community mediation and labor mediation specifically. And then I headed up the education and training division there. And once the CCMA was formed, we got involved in training the first group of CCMA commissioners as mediators, conciliators actually, and arbitrators. And I've been in this area ever since. I joined Conflict Dynamics 10 years ago as a director of the organization, and before that I was a commercial and civil mediator with the organization. So yeah, a history of working in conflict management, dispute resolution, and of course a very specific interest in mediation. Oh, so that's me, Yusuf.
Thank you kindly. Tefo, would you like to introduce yourself to all the members?
Hey, good afternoon. I am a director at Cheadle Thompson and Haysom Attorneys. In fact, I chair our board. I was introduced to mediation in January of 1990 in my first 2 weeks of articles at Cheadle Thompson, where I was involved in that huge railway strike that occurred then. And very soon after that, I got trained at IMSA as a mediator, and so that makes me a mediator of over 30 years, really, experience. I'm also a trainer and assessor of aspirant commercial mediators under the auspices of Conflict Dynamics. I'm an accredited, CEDA accredited commercial mediator. And I'm also a co-founding director of ISO Dispute Settlement, even though I'm now a mere panelist as we speak. That's now my relationship there. Thank you very much.
Thank you kindly. I'm now going to turn the workshop over through to yourselves. You're welcome to proceed to give us an introduction and take us through your presentation for conflict dynamics. Thank you.
Great. Thank you, Yusuf. Just want to check with you that you can see the slideshow that I've just put up. No, doesn't look like it. Sorry about that.
It was there, Marion. We could see it.
Oh, excellent.
There we go. It's there. Thank you.
Okay, great. So you're able to see the first question, which is why the interest in mediation?
No,
Oh, no,
No, we're not.
sorry, Marion.
Marion, sorry, you're going to have to try again.
It's a mediation officer.
Technology sometimes fails us.
Mr. Ntuli, I'm going to ask you just to switch off your mic. Thank you.
Okay, just give me a moment.
That's
Yeah.
perfect.
You got it.
Voila, Fantastic. Great. Thank you.
Meetings
Okay,
or-
so really, I mean, Tefo and I, as you can hear from my introduction, have been involved in this arena for a long, long time. And we've worked, I guess over the years at promoting mediation and acting as mediators and training mediators. So it's really exciting for us that there's kind of a newfound interest in the area. And it's exciting to think of what the possibility is as we go into the future. I think the interest, though, started probably in earnest in 2020 when Rule 41A was triggered, and also then triggered a whole lot of interest in mediation. We certainly saw a massive increase in the requests for mediation after that rule was brought into force. And we've been running a panel of mediators, of independent panel of mediators, as Yusuf said, since 2016. So we got a sense that suddenly people were interested and started using mediation more regularly. I mean, of course, there is also the reason why there's an interest is because you as attorney have a duty to advise your client of the option, and there's case law which should we just
Apologies. Nadia,
no?
can you please switch off your mic? Thank you. And can I ask everyone to ensure that during the presentation, your audio is switched off? Thank you. Apologies for that. Please proceed.
Great. I mean, please feel free to put questions into the chat because, Tefo and I won't be speaking at the same time, so we can always keep an eye on the chat as well if you would like to put a question in there for us. And as Yusuf said, we will have an opportunity to take questions at the end of the session. Yeah, but just back to, why the interest now. I think we've got a very, very established mediation industry, really, in labor mediation in this country and also in family mediation. We've had an attempt at court-annexed mediation in the magistrates court level, and I'm afraid that did not go as well as everyone had hoped. And one really hopes that if there's going to be a mandated mediation process, which we're expecting, given what we've been hearing, then we've learned some lessons from that court-annexed mediation process, which really didn't get past its pilot phase. The other reason I guess we're all interested is because there certainly has been a change in mindset. Commercial realities, I think often dictate that litigation isn't always affordable. So this is a way of circumventing that and getting people to agree, find consensus, rather than deal with very, very long periods to wait for court dates and the likes, and expenses and the emotional expense as well, which is a real consideration in terms of just being in dispute or having a pending matter. Costs we've mentioned, and then we've also just seen how companies and institutions and sectors move closer and closer towards mediation or some form of kind of negotiation rather than adjudication. And we've certainly seen that in the insurance sector, which have a number of tribunals that operate, the financial services sector. We've seen it, we train mediators at SARS, at the South African Human Rights Commission, at the Gender Commission. Across the board, there are more and more people trying to rely on consensus building rather than decision making. So that I guess would be our assessment of why the interest in mediation. I'm going to hand over to Tefo just to speak about the next point, which is really what mediation is, just so that we're all speaking the same language and around this.
Okay, So essentially, mediation is a facilitated negotiation. One of the things that I think is significant about it is even if a third party helps parties deal with a matter, it's easier for parties to hear each other through an independent party person rather than between themselves. Some people have called this the phenomenon of reactive devaluation between disputing parties. So there's no big magic there. It's all psychological and learned skills. Now, mediation depends on a number of essential ground rules. The key ones are in no order of preference. That the process is confidential and without prejudice. And this is repeated throughout the process by the mediator just to remind the parties, because it helps create a safe environment for parties to explore options of possible settlement. That, coupled with neutrality or impartiality of the mediator, is key. I know we use the word neutrality a lot, but I prefer impartiality because it's very hard to be neutral, and very often you do have a view about things, even though you need to manage yourself and be aware that you've taken a view. The third essential ground rule is that the mediator acts as a facilitator. They are not an advisor, they are not a judge, they are not an adjudicator. Their job is to manage the process. And of course, the reaching of settlement is voluntary. In other words, that is up to the parties whether they are going to settle or not. And in fact, participation in the entire process is voluntary. And finally, the settlement, once it's reached, then is what becomes final and binding. So throughout the entire process, there is nothing final and binding, which, as I said, allows for a safe environment to explore options and play around with possible outcomes until that takes parties to a point where they're able to reach agreement and settle. So in summary, then the mediator manages the process, and the parties are responsible for the substantive aspects and the outcome. What does the process look like? There are four main stages. The first stage, which is really around preparation, the parties engaging, appointing an agency to assist with mediation, understanding what the process entails, and so on, pretty much preparing for negotiations. And then formally, then the mediation would start with a joint meeting between the parties where they make opening statements. And that then moves into a process that provides for side meetings or caucuses between the mediator and each of the parties. And in these side meetings is where a lot of information is shared, where again the parties are reminded of the confidentiality and the without prejudice nature of the conversation. And more importantly, then, as information is generated in these meetings, where parties are encouraged to have a broader outlook on the issues, there is an analysis of the dispute, the development of options, there's problem solving, and so on. The key here is that any information that the mediator then thinks would be useful in taking the mediation forward and would be useful if the other party knows of it, it is in this side meeting that the mediator would then ask for permission from the party that is in the side meeting to convey that useful information to the other party. And that's something that is important to maintain throughout the process. And then, of course, there's the concluding stage where agreement is finally reached. and reduced into writing. And the parties shake hands and go away, or they don't reach agreement. There's a deadlock. Usually, hopefully, for us lawyers, at least at this point, even if there's no agreement, the parties are able to perhaps agree on a narrowing of the issues for further stages which involve litigation. Okay, and the next slide. We deal with a pictorial of what mediation looks like. You see in the middle table there, that's the two parties on either side of the table with the mediator at the top of the table, and usually that's where the joint meeting happens at the beginning of the process. And then as you go further into the process, then you have the side meetings, and you see the parties on either side sitting only with the facilitator, where the process is the conversation that I've just referred to takes place. So the phases, which is the next slide, in the mediation process, I've already touched on them. There's the preparation. Then in the formal mediation process, you have the opening statements. And then from there, usually, we then go into side meetings to follow up on these other phases, where you explore and analyze the dispute, generate options for consideration, where the parties then choose options and bargain. And of course, the facilitator, the mediator, is encouraging and helping the parties develop all these concepts until you then reach the final part, which I've just spoken about. And sometimes then either it ends there, sometimes there are follow-up issues after the mediation that the mediator may need to take up with the parties. If not the mediator, perhaps the agency itself. Okay. Marion, this is you.
Yeah, I mean, maybe just to speak about the numbers, I think there is a lot of uncertainty as we kind of wait in anticipation for this directive as to how useful mediation can really be. And I thought it might be useful just to report that last year, that's the last financial year, which is just kind of completed for us. We complete our financial year in February. We had a 92% settlement rate on mediations that were offered through conflict dynamics. So that gives you a good sense that people who eventually agreed to mediate and thought it would be beneficial to mediate, our mediators were able to settle 92% of those matters who came through our doors last year. This is high, I have to say. It's high in comparison to kind of international practice. We work closely with an organization in the UK called CEDA, and CEDA usually says their settlement rate is 75% on the day of mediation, and an additional 10% usually settle in the 2 weeks after mediation. So that's in an instance where they do have the time to settle. And they do actually, at CEDA, run a number of programs that are court mandated and also private matters. So when matters are court mandated, maybe they don't have the luxury of 2 weeks to continue the negotiation process after the actual day, if there are specific timeframes involved. But, the settlement rate is between kind of 75 and 85%. So that does give you a sense of the fact that it actually does seem to work really well. And certainly our experience in the last year was that it was working very well with a 92% settlement rate. So that's really just to give you a sense of it working. I mean, the other thing that I think it might be useful to mention here is that the matters that we deal with are very, very varied. So some of the mediations that come through our doors are very large matters. I mean, we had a mediation last year that involved multiple parties. It was a very big mediation in the oil sector specifically. It involved about 6 different parties, and it amounted to literally billions of rand of claims that were in dispute, which our mediator was able to work with over a very long period. So it wasn't a short mediation at all. It ran across the whole of last year. That's sort of the one extreme. There are other examples of commercial mediations that come through our books, which are maybe, the claims are maybe sort of in the mid-millions, and they get settled in mediation. I had one last year as well. And then we also have relationship issues, so workplace mediations between people, just to deal with their workplace behaviors and how they're dealing with each other in the workplace, which are often much shorter and don't involve any financial settlements. So there really is quite a large difference in all the different type of mediations that we've seen in the last year. But just to give you a little bit of that background before passing over to you again, Tefo, just to speak about why mediation works, or why we think it works.
Thank you. So I think, as I stated, the ground rules for mediation provide a very safe space to explore issues with a view to parties finding each other, and this is obviously guided by an independent facilitator. And the key thing here is that the focus of the conversation is on what the needs of the parties are, or the interests of the parties, rather than an evaluation of their positions, which often takes you back to how strong their case is, they believe their case is, and it really takes you backwards. It's what led to the dispute in the first place. So often what mediation tries to do is, perhaps let me just take a step back. When we speak about focusing on needs and interests rather than positions, I mean, I'll give you a simple example. Let's take a wage negotiation, and a union is demanding a 10% increase. That's a stated position. What mediation tries to do is to dive underneath or behind that stated position or demand to understand what motivates it, what's behind that stated. And perhaps the union may say, well, the price of transport has gone up, and that's why we are asking for 10%. If it hadn't gone up, perhaps we could settle for 8%. The other party says, okay, we have an old bus here that we can use to transport employees. So if you have the bus, would you then accept the 8% kind of thing? But that's really what we mean by focusing on interests rather than positions, or exploring what underlies the positions. I've put it very simplistically, but that's pretty much what it is about. And then, of course, the matters get complicated in different ways. But at the end, you're still trying to distinguish between positions and interests, and to get the parties to focus on their interests. And mediation works particularly because the focus is on understanding the present, dealing with commercial realities, dealing with personal and emotional realities and managing those, guiding the parties to move away from the past, as I said, where parties then would try and reiterate how strong their case is and so on, and to focus on the future, on the future relationship. What are the opportunities in the future? Is there purpose in maintaining a commercial relationship? What happens after the dispute? And very often parties then start seeing the light and are able to then start looking at, okay, how do we make this work? What would make this work? What would make it work for me? What would make it work for the other party? So essentially, just in a nutshell, this kind of space and focus is really what makes mediation succeed. And it succeeds most of the time. And even if it doesn't succeed, as I said, very often for lawyers, at least you know that you're able to narrow the issues and get agreement usually on what the narrowed issues are, are.
Thank you.
So I think I've already indicated how a mediator, through exploring options and understanding the dispute and so on, encourages a very holistic view of the dispute, particularly looking at the present and the future as opposed to being locked up in the past. And at the end of the day, settlement becomes possible when all is said and done. What's on the table is better than what the best alternative is. This is something we refer to as BATNA, the best alternative to a negotiated agreement. In other words, if you don't have an agreement, what's the next step? What lies out there for us? And so very often for the parties, part of the best alternative may be litigation, but then litigation means an unknown. You don't know what the outcome is going to be. It's a zero-sum game, and it may be better to be part of crafting your own solution in a mediated process rather than leaving it to a third party. Or the best alternative may be locking out employees or going on strike. But can you afford to go on strike, or is it better to take a deal because the environment is just not conducive for a lockout or a strike? And in conclusion, I guess we make the point that lawyers, particularly lawyers which is most of us, I would hope, who have the best interests of their clients at heart, become frustrated because the litigation route, as I said, doesn't often answer the real needs and interests of clients. It's a zero-sum game. It's finding for one party costs and so on against the other party. The commercial relationship is spoiled, and so on. So mediation, on the other hand, offers opportunity for creative solutions where the parties craft their own outcome that suits them and advances their future relationships. So I think in a nutshell, without trying to teach mediation, I hope that gives some sense of what the process entails.
That's great. Thanks so much, Tefu. And I guess that takes us on to kind of the other aspect that we were asked to focus on, and that is becoming a mediator. Or, I think many people are looking at this more actively, given the directive that we're expecting any moment. So just a little bit of information on that, on the training that we offer and how we go about it. So I mean, I think the one of the fundamentals that's been agreed on in this consultation process so far, I mean, the proof will be in the pudding. We'll see what the directive says. But what seems to be general agreement on is that mediators need to be accredited to do the work that they say they can do. So it's really important to make sure that if you're going to be mediating, that you are trained and skilled and capable of facilitating a mediation process. And it does differ somewhat in the different areas that you want to focus on. So if you are wanting to work in civil commercial arena, then you need to be trained as a civil or commercial mediator. To be effective in the family or divorce arena, you need additional training to be able to operate there. And many of us in this country have come from a labor management background where mediation is quite established in the legislation and in practice, really, in that arena. So you decide where you want to mediate, and you make sure that you are accredited to operate in that sphere. So I think there's been a bit of a sort of a show and tell process that's been happening here at the GAA in the last couple of weeks. I know you saw our colleagues from MIM, Mediation in Motion, last week, and we're here telling you about our ways today. But you just need to have a look at who offers good mediator training programs. Try and choose a provider that is accredited, specifically in this instance in the South African environment by DISAC, who is the voluntary body that manages standards and I guess discipline at this stage for the industry. So look at who's offering those courses. Expect that you'll spend at least 40 hours in training. So it's a big commitment, but 40 hours is the international standard for entering the mediation field. Make sure that you are sure that it's actually an assessed course, so your capability is going to be fully assessed, because there are courses out there who suggest they're going to do assessments, but the assessments are not necessarily independent, and you don't get the feedback on whether you've reached, whether you're able to work with the competencies that are being trained. So check on that. Yeah, make sure that the people who are training you are experienced mediator practitioners, because this is something that is a skill. You can learn it. Anyone can learn it if they're really prepared to apply themselves. But it's really much more beneficial learning from people who understand how to apply it at the end of the day. Make sure it's competency-based. And yeah, I mean, in order to complete it, there's probably quite a lot of pre-work and post-work that needs to be done. And we emphasize quite a lot in our training that it's very easy to get back into bad habits when you're a mediator. So it's really important to continue your professional development throughout. Yeah, that gives you a bit of a sense of what to look for. Also very important to make sure that it is accredited with the right bodies. Our course is CEDA accredited, and you also, if you complete our training, qualify for IMI accreditation, which is the International Mediation Institute. And we also offer, and I can speak to you a bit about this later, not everyone wants to become a mediator, of course. I mean, that might flood the market completely. And you may just really like, you know, representing your client. I mean, there's an extremely important role in mediation for people representing their clients effectively during the mediation process. So working with the process, being useful to the process and to the client. So we also offer a one-day course on what we call mediation advocacy, but it's really about how you prepare and represent your party effectively in the mediation process. Yeah, so that's just a little bit about the training that we offer. I've got a lot of detail here. I'm just trying to think about time. I probably need to finish in about 5 minutes. Am I right, Nicolette?
That's correct.
Yeah. So I've probably got to finish quite soon, but just to give you a bit of a high-level overview, and then we can open for questions. We do our training over a 5-day period. Usually we do it over a weekend, or 1 day over a weekend, just to give people, to allow people not to have to take 5 days out of their practice. We understand that's difficult. We do, however, usually take one of the weekend days off, because we like people being able to have the opportunity to prepare for the assessment. What happens is the first 2 days is purely tuition. We give you the theory, we give you the philosophies, we give you the different skill sets that you're going to need. You do start practicing those skills from the first day, but it's really giving you the facilitated mediation tools really in those first 2 days. The third day is a coaching day where you practice those tools with everyone in the room, and we have independent coaches come in and give you feedback, give the group feedback generally, so that the learning continues, but then give you as an individual feedback on what you're doing well and what you still need to improve on. So it's a very interactive day of really sitting in the chair and practicing those skills. And then the final 2 days are the assessment days. And for those days, we again get in experienced mediators who are also trained to assess and they assess you according to the competencies that we've been training for the previous 3 days. And the assessment, and then you get feedback from your specific assessor on how you did, and you then are, I guess, are found to be capable or not in terms of those competencies. We also have, so just to explain our process. So we try and give people the Sunday off to prepare for the Monday and Tuesday's assessments, because they are really, they're real case studies. They're quite intricate. You playing the roles or you mediating, which means you need to understand the process quite fully in order to do that. And there are a number of these cases each day. There are actually 3 different case studies each day, which you'll be working with and assessed according to how you actually participate, but also how you mediate in those matters. And then we post-course have a post-course assignment, and pre-course we have a pre-course assignment to make sure that you're dealing with the issues around it. So the theory up front and the contracts at the end. So our post-course assignment looks at agreements to mediate and settlement agreements predominantly, to ensure that you're able to complete all those aspects of the process that Tefo spoke about earlier. Okay, so that gives you a good sense of what we'll cover in the mediation process. I also would like to just give you an opportunity to see what we cover. I'm not going to go into the detail, but I want to give you an opportunity to, sorry, I'm trying to get to the end here, to the content of the of our advocacy course, which is a 1-day course. And in that process, we speak about the different dispute resolution processes. We look at mediation and, what mediation does. We look at the process, the principles, the ground rules, so that you become very familiar with that as a representative. It's very much geared towards people who want to represent rather than mediate. We speak about what makes mediation work, what lawyers do in relation to the mediation process, and our approach is very much that lawyers are very, very involved in the process. They are usually the people who instigate the process, and throughout the mediation, the mediator is really working actively with all the parties, but particularly the lawyers to get the process to a settlement, or to, as Tefo said, narrowing down of the issues or a settlement on some of the issues at least. So we encourage, and we just find it so much easier if you have lawyers in the room and they're working with the process actively. It's a real benefit to the mediation process. We deal with how you advise, how you do the risk analysis really with your parties, and we also give an overview of the different laws and regulations that guide the process, including Rule 41. And then we speak about the logistics of the process too. As Tefo indicated earlier, there's a big kind of build-up to a mediation process. Getting the logistics in place and getting the right mediator for the matter who's qualified and experienced is really a big part of the actual process. So we speak about that as well in this advocacy course. Okay, and I think that kind of takes me, I'm just checking my slides here. They're hiding behind my, I mean, I can give you a sense of our training. We schedule public courses up front at the beginning of the year. We've had one already this year. We have the next one coming up in April, which is, I think there's only one place left on that course. We never train more than 18 people at a time because it's a skills-based course. And it's a very, we give you the opportunity to practice those skills. So these are the courses that are left for this year: June, July, up here in Sandton, September in Cape Town, and November in Sandton again. These are the public courses. We do in-house courses as well. So if you, and I mean, I think Nicolette spoke to me about, well, would we be prepared to come and train in Pretoria? Of course, we would be prepared to train in Pretoria or anywhere, but we would use that as what we call an in-house course. So you would, collect the attendees for that course, and we'll come and do it wherever the need is. Yeah, mediation advocacy courses are also advertised. They're usually, well, not always, because we have had a couple of law firms who've asked us to come in and train only their attorneys on the advocacy aspect, but we also have public courses, and that's available on our website. And finally, we do a lot of mediator professional development. So at the moment, we're training mediators on how to deal with RAF matters in preparation for the directive. We've trained a lot of medical malpractice mediators before. We're going to be doing more of that training just to make sure that people know how to deal with those matters. Court-mandated mediation is different to private mediation, and we'll be running courses on that in the upcoming months. Just general refresher courses we've trained over the years since 2007, when we trained our first group of commercial and civil mediators, which Tefo was a member of that group that trained in 2007. We've probably trained about 1,000 mediators in South Africa since then, since 2007. So we just want to be sure that whoever we put out there is refreshed and really able to deal with the processes, because if you don't use the stuff, you lose it. So we really do encourage people to come back for those refreshers. And then there are always sort of advanced mediation skills that we look at. So advanced facilitation skills, how to build rapport effectively, how to problem-solving techniques, we focus in on some of those as mediator professional development processes, at least throughout the year.
Thank you kindly.
So that gives you a good sense of what we do, I think.
How can members access mediators? What is the process to follow to access mediators from conflict dynamics?
Well, yeah, so our mediators are all on our website, so you can see who our mediators are. We have a panel of about 70 mediators on our books, and they're all accredited and have signed a code of conduct and are subject to all, our discipline processes. And you as an attorney, if you want to access them, you can go online. There is a search function. So if you're looking for a mediator, for instance, to deal with a medical malpractice issue, you can put that into our search engine, and you can get a record of who of our mediators are qualified to deal with those matters. And then you contact us at Conflict Dynamics. You could just put a web query through, or you can phone us. And we have case managers who then will speak to you about what you want, what your, we'll discuss budget with you, we'll discuss, fit, what type of mediator are you looking for? Are you looking for someone who has some experience maybe in transformative relationship issues or needs a specific legal area? And what we usually do is we then put a list of three options to all the parties. So that's really important to us. Parties only come to us once they've decided they need to mediate or want to mediate. So we then usually give them a short list of 3 available mediators who fit their requirements specifically. And then the parties agree on who they would like to contract. And if they can't agree, they list them in priority, and we make we get the 2 lists and appoint the person who's highest up on both lists. So we have mechanisms of just assisting with that selection process. And then the mediator starts working with the parties. We introduce them. We also collect all the fees up front. So we bill parties up front for specifically the first mediation period. So sometimes that's a half day, but mostly it's a day. It depends very much on the dispute. And then they pay for that up front, and the mediator then engages with them and takes the process further.
Thank you kindly. I'm going to open up the floor for Q&As. We do have a few Q&As in the chat box as well. Does anyone want to be interactive? We prefer. So if you do have a question in your chat box, would you like to just ask it here?
There's a question by Aaron. Aaron, do you want to? Yeah.
Please go ahead, Aaron. You can switch on your mic and switch
Yes,
on your
I did, and I got it
Thank you.
right. Thank you very much. Right. So my question is that does conflict dynamics provide credit if you are accredited in the basic principles of mediation and obtained your mediation training from another accredited training provider, such as a university or another institution offering similar training? And additionally, would one need to complete the entire training again if, for instance, they previously did commercial mediation but now wish to focus on RAF mediation? That's my question.
So Aaron, we had a training on the RAF mediation specifically last weekend, and we advertised it broadly, and we had people attend who have not been trained by us. We assume that they've been trained by someone credible, and we've given them the skills, the RAF kind of context and legal and administrative context. That does not necessarily mean we would put them onto our panel, because we can't vouch for other people's training, but we definitely do make our training available to people more broadly. So I hope that answers your question.
100%.
Great. Then Harry's also asked a question in relation to getting buy-in in commercial mediation. Harry?
Yes, hi. What I've experienced in my practice, particularly in relation to high conflict matters, and typically high conflict matters between shareholders, where I've been batting on and banging on and encouraging my clients to embark on mediation, and my opponents, I've met with very strong resistance, because there's a fear and a misunderstanding that mediation is like a court case and that it's binding. And try as I might, I've been largely unsuccessful in persuading opponents who I find do lip service to Rule 41A and my own clients into accepting mediation and to embarking on the process. And I was wondering if you've got any thoughts as to how we as lawyers should address this.
Therefore, can I leave this one to you?
Why are you leaving the most difficult one to me? Yeah, this is it's an area that we need to work a lot on. I think it's about advocacy. It's about really advancing advocacy of mediation and a proper understanding of what it is. I can identify with what you are talking about. Not so long ago, I mediated in a Rule 41 process, and senior counsel was asking me to make rulings on substantive stuff, and I was trying to explain what my role was, and certainly adjudicating on issues wasn't one of them, but somehow that was still the expectation, despite having explained what my role is and so on. So it seems to me there's a great space for more concerted effort on advocacy about mediation, and just talking about it in various platforms and writing about it and so on seems to me to be the kind of only option, really.
Thank you, Harry. Just to
Thank you.
indicate that at this particular stage, when the practice directive comes out, it's now going to be widespread in litigation prior to applying for a trial date. So it's going to now, once attorneys get used to the idea of mediating for their trials, it's going to be growing into the profession. So I think we'll have more opportunities for our colleagues in the profession to consider mediation, because they're forced to at a later stage when you apply for a trial date in any event. So I think that nature is going to change dramatically within that context. Thank you.
Can I just ask a follow-up question
Yes, yeah.
in relation to what you've just said and the words forced to? The concept of being forced into mediation flies in the face of voluntary mediation and is possibly in violation of Section 34, I think it is, of the Constitution, which entitles every party to have his dispute publicly aired in a court of law. And I was wondering if our panel have any thoughts to share on what the practice directive portends for voluntary mediation and how you force a client into signing a mediation agreement.
I deal with a small part of that. So we already have experience in conciliation with the CCMA, because again the CCMA is once a matter gets referred there, parties are in a sense compelled to attend, but then that continued stay is not compelled, because you can't be forced to. If you parties feel the thing isn't going anywhere, or they don't really want to participate, then they'll frustrate the mediation process, and then it will move into arbitration if it's an arbitrable matter, or whether it's something that needs to go to the labor court. So there's already experience of some form of induced, at inception is induced, but the continuation is voluntary, and the outcome is also voluntary in that sense. So there's a bit of that, and I know this debate, particularly in the UK, which has passed legislation also around this time, it was a very hot topic, this issue of forcing people or not forcing people. But I suspect the constitutional aspects have been thought of and taken care of.
Yeah, I mean, there's a recent ruling in the UK, the Churchill ruling, they're referring to it as, which has kind of put the issue to bed there, certainly. And I would say, based on, they're probably about sort of 20 years ahead of the curve in terms of us on this court-mandated mediation and how that changes the process. So I think we'll all be learning. But certainly there is a lot of good experience and a good understanding of how to get the most out of a mediation process, whether it's mandated or voluntary, completely voluntary.
Thank you.
So we look forward to looking at that specifically and how it plays out in the local environment.
Indeed. I think the judiciary is looking at the decision of Constitutional Court Justice Albie Sachs' decision, and that's what they've placed their emphasis on. They can set procedures for parties to mediate, but they cannot force parties to find settlement in those mediations. It's just a process that they're adding to the topic, but they'll take us through that. There is another question in the chat, and I'm going to move on to that one. Okay, details of conflict dynamics is there. How can mediators get experience? And what are the costs of the mediation course? If we can attend to those two, then we'll get to the next one.
Right. I think if I could just deal with the experience, that's a really that's a difficult one. At Conflict Dynamics, we've had a process by which we kind of have tried to encourage people to observe matters. So get yourself attached to an experienced mediator and ask them to take you along. We also request from parties the permission to have an observer. So it is really important to see how it works, maybe initially observe, then co-mediate potentially with an experienced mediator, and then eventually go out on your own. I'm really hoping that this directive will open that up to a large extent, and just with the greater numbers of mediation being in the environment, there'll be greater opportunity to observe and co-mediate and then actually mediate alone. And we're looking at, we're going to obviously we're preparing a panel to be able to respond to that need. And we're looking at exactly that, having a situation where you first observe, then co-mediate, and eventually go out on your own. Or go out on your own and test your skills, because I can assure you, we're training people to be able to mediate immediately, and we trust that they will be able to. We did when we started mediating. So it's not rocket science. It's just the application of good skills. So that's in terms of that. How much our course costs? Our course, if you come on the public course, is 29,070 Rand for a 5-day course. If you do it in-house, so if you contract us to come to you to do a group of people, you know, either in your firm or in your associations, then, you know, we can speak about that. But what our public courses, it's 29,070 Rand for the 5-day course. And if you want the international accreditation that that we offer as an add-on, that's an additional cost, of course, at international fees, because they're the ones doing the hard work, so they charge us in pounds or euros.
Thank you kindly. I'm going to...
Sorry, can I just add?
Apologies, we've reached our end of our time, but I'm going to give you a last opportunity to clarify.
No, I was just picking up on what Marian said about the international accreditation. Now, just for people to understand quickly how it works, is that the whole process that we do locally is recorded, and then the recording is sent to CEDA in the UK, and they use that then to do their assessment. Just to make that point.
Thank you kindly. I'm going to close the meeting on this particular note. I'd just like to sincerely thank both of you, Marian Scheer as well as Tefo Rari Tapole. Thank you very much for your kind time in providing input into conflict dynamics, and to all our legal practitioners who are now faced with the possibility of this practice directive. We look forward to consulting with you and booking your mediators, because the need is definitely there, and most of us will probably want to do advocacy training, and more importantly, try and complete the mediators course as well. Thank you for your kind time, and on behalf of the Gauteng Attorneys Association, I'm now going to declare this particular meeting closed, and we thank you all for attending. Thank you, everyone. All the best. Bye-bye.
Thank you.